She writes, I just want to be happy now. I made up my mind. That is what I need to commit to. Not a person or a marriage, but my own true happiness. What a concept I know. I think some of us have this subconscious belief deep down that we don't deserve to be happy, or that we don't get to be happy until we have suffered or bled to death first. Well, I think I might be one of those people, and as logical as the previous statement is, I have suffered, even bled to death. This defendant who sits before you would, on that evening, take this long, dull knife, as she described it, and plunge it into Mr. Redlick's body. Mr. Redlick is bleeding. He is losing massive amounts of blood. He does not have long to live. He finds himself lying on the floor, looking up at the ceiling of the home that he once shared with Danielle and Jaden and Sawyer. With moments, minutes left in this world. This defendant told you that at some point before 10:50 that evening, that she stood over Michael. She stood over Michael with her phone in one hand and a thought in her head. She told you that she thought it was possible that Michael could be saved because she wouldn't do CPR on someone she thought was dead. And in that moment, Danielle Redlick had a choice. She had a choice to call 911 and get emergency help personnel to that residence, or she could do what she did, which was perform amateur CPR. She is standing over him with the power to help. She chooses in that moment to let Michael Redlick bleed to death. Why? Why did she let him, if she believed he could be saved, die on that floor? She told you, and the state is not arguing, that Miss Redlick intended to kill Michael Redlick. She cared more about not sitting in that chair that she sits in today than saving Michael's life. She goes on in that email that she, in just these perverse ways, brings to life, and talks about how she really wanted the Romeo and Juliet story, a soulmate to trust, melt into, be there, and even die for. That's not the only time you saw this reference to Romeo and Juliet come up. You see in her Meet Mindful account, this desire to have the Romeo and Juliet love. And if we think back to maybe our high school or English class, the story of Romeo and Juliet, those star-crossed lovers, that when Juliet sees Romeo dead, having drank the poison, she arms herself with a dagger and takes her life. 11 or so hours later, this defendant arms herself with a sharper knife, that silver knife that's in that kitchen sink, and she slits her own wrists. And you heard that it wasn't because she wanted to be with Michael in the afterlife. It wasn't because she couldn't imagine a world where she and Michael weren't walking alongside each other. She admitted to you on this witness stand that at least in part, she slit her wrists because she didn't want to have to answer for what she had done. Now let's compare and contrast how this defendant acts when she stabs Michael and he is gushing blood into that home. How she acts when she slit her own wrists. Because it is only when she is bleeding that she dials 911. She thinks to save herself. She told you that. She didn't want it to go this way. When she is in danger that she's inflicted on herself, she calls for help. You have heard through the course of this case the investigation that followed, the physical evidence that was found on scene, the physical evidence that was obliterated by this defendant. You heard about what Ms. Redlick was doing on her phone in the months leading up to killing her husband, what she was doing on her phone the night she killed her husband, the morning she killed her husband. You learned about Ms. Redlick's physical condition when law enforcement arrived, and her physical condition when she reported or she was taken to the ER. You learned about Michael's condition when an autopsy was performed. And you heard Danielle Redlick speak. You heard her in a 911 call. You heard her in that recorded call to Detective Ware. You heard her speak through other witnesses, the statements she gave to Terrell Tucker and Frederick Copeland. You heard her in that search warrant audio on the 18th, protesting, denying her involvement. You heard her own testimony. You had an opportunity through the course of this case to listen to Ms. Redlick and evaluate her story and her credibility. And then you heard jail calls. And you heard two sets of jail calls in this case. You heard jail calls of Ms. Redlick talking on her pen and the conversation she carries on when she thinks she's being listened to. And then you heard the conversation that Ms. Redlick engages in when she doesn't think she's going to be heard, when she thinks that she can talk freely and talk about things that you folks will never hear.
Court TV Live, your front row seat to justice. I'm Julie Grant. Thank you for being with us on this Thursday. We're watching the closing arguments in the kitchen knife murder trial in Orlando, Florida. The state just started up. We had to go to a break because we were nearing the top of the hour, but we hit the pause button so you won't miss any of it. We're going to go back in now where we left off.
Present all this evidence. Why do we present the evidence of Michael and Danielle's relationship? This relationship of two very imperfect people. And all the physical evidence and the cell phones and the records and stuff. It was all presented for one reason. To prove the elements of this offense beyond a reasonable doubt. We talked about the elements in jury instructions, or jury selection rather. We talked about the BLT. This is the BLT. This is the bacon, the lettuce, and the tomato of this case. This charge, the tampering charge, and the lesser included manslaughter charge. All of that evidence is directed at these elements and these elements alone. And it's to these elements that you apply the burden and determine whether the state of Florida has met its burden of proving each and every one of those elements. So let's talk a little bit about second-degree murder and the elements of second-degree murder. element number 1 is not in dispute, okay? Element number 2 is the act of Ms. Redlick jabbing that knife into Mr. Redlick's shoulder. Now, that's a criminal act unless, of course, it's justified. That is the criminal act, and there is, as Ms. Redlick said, a justification for it that you're going to have to consider, and you've been instructed on these decisions and these instructions. And then you have element 3. Element 3 is kind of, I have to imagine, for a group of jurors who've never seen the definition of second-degree murder, probably very strange looking. The state of Florida has to prove that there was an unlawful killing, so an unjustified killing, of Michael Redlick by an act imminently dangerous to another and demonstrating a depraved mind without regard for human life. Fortunately, you get some definitions of what a depraved mind is and what an indifference to human life is, and that's what you see down here, these 3 bullet points, to help you understand that kind of strange formulation in element 3. So let's talk a little bit about the evidence that you have to each one of these aspects that the state has to prove in element 3. We have a person of ordinary judgment would know it is reasonably certain to kill or do serious bodily injury. So in this particular case, the evidence is overwhelming from the defendant's testimony. The size of this knife, and the testimony of the medical examiner, that the choice to take a knife like this and plunge it into someone's body where veins, arteries, organs are all located, a person of ordinary judgment would know that is likely to do the very least serious bodily injury. You know, you take a big old knife and you jam it into someone, serious bodily injury is going to occur. And we have a definition of serious bodily injury. Serious bodily injury means a condition, physical condition that creates a substantial risk of death, serious personal disfigurement, or protracted loss or impairment of the function of any bodily member or organ. So in this case, you have testimony that each one of the knife wounds to Mr. Redlick would have caused scarring to his face, scarring to his shoulder, scarring to his side. You have that disfigurement. Then you also have this very clear evidence of protracted loss or impairment of the function of any bodily member or organ. Specifically, you have the testimony that relates to the fact that that knife travels through into the shoulder, through the skin tissue, hits a vein, goes through a pectoral muscle, and then enters into the chest cavity. And the medical examiner talked about how devastating that is going to be for a person, and then continues further and actually pierces the lung. You saw the hole in Michael's lung. That is, without any serious dispute, the type of injury that is going to cause protracted loss or impairment in the function of any bodily member or organ. That is the state's evidence as it relates to the serious bodily injury portion of that instruction. The state is not saying, because, throughout this case, Ms. Redlick has made statements about how she didn't think that, she was surprised that Michael died. And I think it's a dangerous game to put any stock in things that Ms. Redlick says, but it's not entirely unreasonable that you stab someone in the shoulder and you don't think you're going to kill them. And the state probably agrees with that. That when she stabs him there, that everything that results was a bit of a surprise at the end of the day. But the state doesn't have to prove that she intended to kill him, or even that she knew that the location of that stab wound would bring about death. But an ordinary person knows, big old knife into someone's body, deep enough to hit their lung, that element and that aspect of that element has been proven. It is done from ill will, spite, hatred, evil intent. And that was where a lot of this case was sort of played out, is showing you this relationship. Ms. Redlick talked to you about the relationship, but the state showed you hard evidence in the form of these emails, these journal entries, and that jail call on that alternate PIN number where she talks about Mr. Redlick and how terrible he had been for 5 to 6 years and how he had just been awful to her and sophomoric and nasty. And you see in that email on the 14th of December, he's a lying, rotten son of a bitch. This is how Miss Redlick felt about Mr. Redlick. And this is how she felt when she plunged that knife into his shoulder. She certainly had ill will. I submit to you that she had hatred, but I don't have to prove each and every one of them. I only have to prove one beyond a reasonable doubt. There's ill will. I submit evidence of hatred. I submit evidence of spite. And certainly, the decision itself evidences evil intent. This was not done with anything but an evil intent. And so, as it relates to that aspect of what I have to prove related to element 3, the state has proven beyond a reasonable doubt that aspect. Now, the third portion is of such a nature that the act itself indicates an indifference to human life. And in many ways, everything I just said sort of goes to this, is that the choice to take this big knife and plunge it that deep and just see what happens is indifference. Because once again, inside your body are all the things that keep you alive. And when you start jabbing sharp objects into the areas of your body that keep you upright, you are telling that person and you are telling the world that you are indifferent to the consequences. But there's more. There is what Miss Redlick told you she did. She told you from her own mouth that she believed that he could be saved. She believed he was not dead. She let him die. If she was right, she let him die. And if that is not indifference, if that is not putting your life and your interests ahead of the man laying on that floor, then the state of Florida does not know what else is. And the most important, not the most important, but the thing that you must sort of understand is that the state does not have to prove that she intended to kill him. They cannot prove that. It does not have the evidence that this was an intentional killing. It doesn't have that evidence, it hasn't offered that evidence, and it wasn't required to provide that evidence. So that's second-degree murder. And we talked about, in jury selection, all the questions that come up in the course of a trial, and all of the questions that come up in the minds of a juror that may seem extraordinarily important. And that if those questions don't relate to the elements, they are not a basis for reasonable doubt. But that doesn't mean that you might not be sitting there with certain questions about why this happened. And the state of Florida does not have to prove why. The state of Florida cannot tell you definitively why on this night Danielle Redlick decided to do what she did. It doesn't have to. And I will not get up before you and tell you I know. I will not get up before you and speculate and say, oh, this is why this happened. But what the state of Florida has done throughout the course of this case is given you context to understand this defendant, this relationship, and what was going on in the months, the years, weeks, and days before she murdered Michael Redlick. Defense in their opening statement talks about how Michael had this power dynamic. In the state of Greece, there was a power dynamic in this relationship. Michael Redlick was older. He had the job, a prestigious job, a string of prestigious jobs. He had the money. He had the connections. He had the power within the relationship. Danielle told you, she told you, you don't have to rely on me, these words came out of her mouth, that when she filed for divorce, Michael weaponized this, weaponized it against her, and threatened her that she'd be out on the street and she'd be destitute. You saw the divorce petition, how she had sought sole and exclusive access and rights to that home.
What do you think? Has the state proven that this was a murder? Remember, they've got the burden. Even though she put on evidence, she doesn't have to prove a thing in terms of the elements of the crime here. We know this is all on the state, and right now the prosecutor is going through them one by one. He called it the BLT when referring to those elements. We're going to take a break. We're hitting pause. You won't miss a thing. We're right back after this.
Danielle Redlick charged with the murder of her husband, who was once her stepfather.
He stabbed himself.
But will the evidence paint a different picture for this jury?
The kitchen knife murder trial. Live coverage today on Court TV.
.com today.
Welcome back to Court TV Live. I'm Julie Grant. We're watching the final arguments in the kitchen knife murder trial. Defendant Danielle Redlick on trial, accused of murdering her husband, Michael Redlick. Right now, the assistant prosecutor's name is Sean Wiggins, is giving the state's close. We hit the pause button so you wouldn't miss the arguments. Let's go back in together now.
What you learned is that on December 5th, 2018, she begins to make a series of decisions engaging in this activity related to meet mindful and talking to other men that Michael Redlick will eventually discover. And the state of Florida offered the email on the 14th because it submits to you that it provides context for who she is as a person and how she was acting within this relationship. And this is in evidence of States 58. So while Danielle Redlick has joined a dating app, and you saw this wasn't just a thing where she joined and then never logged back in. Literally, I won't say literally because I may be wrong, but go through that timeline and you can see it sure seems that every single day she's on that application, matching and viewing and matching and viewing. And she's apparently connected with this Caesar individual that while she's doing that activity, she dives into Mr. Redlick's email and she finds this email from 2012. She digs it up, she forwards it over or sends it to him, CCs herself, and calls him a lying, rotten son of a bitch. I'm done with you, Mike. We should talk about ending this. I'm ready. You're the most untrustworthy person I've ever known. And I have every right not to be with that person. While she is herself trying to meet men outside the marriage, while she is herself listed as separated on that app. Why does this matter? Well, the state submits to you that it establishes some context for what comes next. Because on the 10th of January, 2019, she's caught. And on the 10th of January, 2019, Danielle Redlick has lost the one thing that she can hold over Michael Redlick. That until that point in time, he was the cheater. He was the one who had been unfaithful. And now she was. So the one thing that she drags out and uses to call him a lying, rotten son of a bitch, she doesn't have anymore. And she knows the divorce is going to be more difficult and everything that's going to come with this. And you heard that Michael is sarcastic and sometimes sharp with his tongue. And this is what's going on leading up to and on the 10th and onto the 11th. And the state of Florida will not get before you and justify how Michael Redlick acted on the 10th. Maybe some of us can understand it, but I'm not going to attempt to make it okay or say, oh, this is why it's understandable. He found out that his wife was talking to other men, and he reacted in quite a upset way. Is that understandable? Is it not? That's for you to decide. But not really, because unless it relates to the elements. But in any event, that he is upset. He is upset at this point, and that's what's going on as we lead into the 11th. But why? Why on that night does it happen? I can't tell you. I can't tell you. I don't have to tell you. The state doesn't have to tell you why. It only has to prove those elements. But all of this context, the understanding of this relationship, the understanding of who she is, helps make some sense out of the senseless. So let's jump for just a moment and talk about Tampering. We will see in just a moment whether the defense makes an argument that she's not guilty of tampering. It is going to be a tough argument to make, because if we look at the elements of tampering, it is as clear as it could be that she engaged in evidence tampering. Her husband is dead on the floor. She tells you she knows that in the late 10 o'clock, 11 o'clock hour. Sawyer and Jaden are eventually coming home, and she knows that at some point the police are coming and an investigation is happening. There is no doubt that that's going to happen. She knows it's going to happen and she tells you that she knows it's going to happen, not just by any words, but her actions. She knows an investigation is forthcoming, and that's why she starts to do everything that she does. She is not cleaning the house because she's worried about house guests that are going to be coming over in 48 hours. She is cleaning the house to make this scene look like something it's not. And that's why what she says when she first picks up the phone to 911 is so telling. It was a heart attack or something. I think my husband's dead. She is endeavoring in an attempt from the start, when she knows that the police are going to come knocking and this investigation is inevitable, to change that scene. To make this be something that doesn't land her where she sits today. And not only does she clean up the scene, and you heard from Stuart James. I'm not going to go into his testimony in detail. All of you were paying attention throughout the course of this case. You heard how basically from corner to corner of the scene, she altered it with mops and towels and water and what appears from the testimony of the officers that responded, cleaning solution. The trash that's got blood on it. Everything she did to change that scene so it could be something it's not. But there's more. She decides in those moments, she tells you early on, she doesn't give a very clear explanation for why, that she takes out her phone after she's murdered Michael Redlick and she begins deleting text messages.
Objection, improper argument. Judge, can we approach?
Yes.
All right, so the defense is saying there was an improper argument made. I didn't hear it. Let me bring in my guests and see if they heard it. I want to welcome into the conversation attorney Melba Pearson. She is a former homicide prosecutor, and still with me, retired police sergeant Melissa Pinkleton. Great to have you both. Melba, to you first, if I may, please. Was there anything improper you heard about what the prosecutor said here?
Great to be here, and absolutely not. Everything sounded within the boundaries of argument, because remember, this is all argument, and the judge can advise the jury to remember that this is argument and they need to rely on the evidence as presented in court. But I didn't hear anything that was completely inappropriate or outside of the bounds of the usual closing argument. It does get heated and passionate, and that's the way it's supposed to be.
Right. Amen, Melba. Amen. Yeah, I was liking it when he said she murdered her husband and she's deleting the text messages. He's just telling the story based on the evidence that we know is admitted. And I didn't hear the attorney saying facts not in evidence, which is another objection. So I'm not sure what he's doing here. It seemed like he just wanted to get up in front of Her Honor at sidebar so that the jury doesn't hear it and we can't hear it because it's not an open court. Okay, so with that, I do have another follow-up for you both as to how the state is doing so far. Melba, do you like counsel's presentation up to this point?
I do. The only cautionary thing I would say is that he was using words like sophomoric and all of that. Sometimes it's better not to, I'm not saying dumb it down, that's not at all what I'm saying, but sometimes using simpler language is more appealing to the jury, because if you start using those $10 words, it can sometimes turn people off, and that's the last thing you want to do. You want to come across as personable and of course credible, and staying within the bounds of the evidence, but make it simple for everyone to understand. Now is not the time to showcase how smart you are.
Exactly. No, that's a pet peeve of mine. Sergeant Pinkleton, yesterday when I was hearing that prosecutor do some of the questioning of the defendant on cross, and he was asking her about the egging situation, how she threw eggs, that her husband egged his car, and he was saying things like, you know, he got egg on his person. Who talks like that? You know, you just say you egged him. You threw eggs at your husband, you know, the man you married, the father of your kids. You egged him. That's how you say it, not sounding like a lawyer or like a police officer, right, Sergeant?
Absolutely. You want to use layperson terms so that, because you're right, no normal person other than law enforcement or somebody in the law enforcement community says on their person or with their person. You say, yeah, you egged him. You egged his car just like a teenager would. And so I agree with your other guest in that you don't want to sit there and use, as she referred to, $10 words. You want to use lay terms so that everybody can relate to the same exact thing. But I think he's knocking it out, and so far, given the facts, and going and laying it out step by step.
Okay, what we're going to do is hit pause here, because clearly there's a break in the action with the close. We're going to figure what's going on with that objection as we have to hit a break, because we're at the bottom of the hour. Don't go anywhere. This is the closing arguments in the kitchen knife murder trial. You're watching Court TV Live, your front row seat to justice. By Whisker. So much for being with us on this Thursday. I'm Julie Grant. So what we did during that break was we rewound the tape for you in Florida so you could see exactly what the judge was saying to someone in the gallery about people making noise. They were just up at the bench having that argument at sidebar with Her Honor about whether or not the state was making improper arguments. So let's go back to that moment right now.
Hold on just a second. When I have bench conferences, I need you all to keep it down. The excessive talking and the loud noise is very disruptive and distractive. If you can't do that, kindly leave. Mr. Wiggins.
So in addition to just obliterating all of that blood evidence inside the house and doing quite a thorough job in the kitchen, she begins to delete text messages. And that continues to tell you what this defendant is doing and what she is guilty of, and how everything that's happened since the moment that she's put that knife inside of Michael is to avoid responsibility for her actions. She can't explain why she deletes those messages, but it certainly makes her guilty of tampering under the law. So then we'll talk about manslaughter. Manslaughter is a charge that you only consider once you've decided as a group. All 6 of you look at that second-degree murder charge. If you unanimously decide the state has not proven manslaughter beyond a reasonable doubt, that is when, second-degree murder beyond a reasonable doubt, that is when you consider the lesser included. So you don't just sort of jump down to it. You start with the highest, and then you go to the lesser if the state hasn't proven the higher charge. And the only lesser included offense in this case, it is manslaughter. So manslaughter, are in many ways more straightforward than second-degree murder. Michael Redlick is dead, no dispute there. Danielle Justine Redlick intentionally committed an act or acts that caused the death of Michael Redlick. So you commit an act, intentionally so, and someone dies. You have this language, every person has a duty to act reasonably towards others. If there's a violation of that duty without any conscious intent to harm, that violation is negligence. And you cannot be guilty of manslaughter by committing a merely negligent act. So for example, you're driving home, you lose control of your vehicle, and you hit another vehicle and someone dies. You did not intend to do that. You were involved in an act that killed someone, but you didn't commit an intentional act. You may have been negligent in the way that you're driving. You might have been looking at your phone. You might have not ever changed your tires. You might have made a series of really, kind of questionable decisions, but you didn't do anything intentional. That's an example of a death that wouldn't make you guilty of manslaughter. Here's an example of a death that would make you guilty of manslaughter. You're in a bar fight with some guy that you just met. You'd spilled a drink on your shoe. And you look up and you punch him. He falls, he hits the bar, cracks his head and dies. You never intended to kill him. You didn't really know this guy, and all he did was spill a drink on your shoe. You didn't know him from Adam, but now he's dead. You're guilty of manslaughter. The principal difference between manslaughter, or the big difference as you see between manslaughter and second-degree murder, is that second-degree murder accounts for a murder that occurs when someone has had the opportunity to develop some sort of animus, some sort of enmity towards another human being. Precisely as Ms. Redlick had. She did not commit a manslaughter. She committed a second-degree murder with a weapon. Now, we'll talk about that aspect of this decision you have to make at this point. So, you find her guilty of second-degree murder or manslaughter. You would check off this particular form. Here, or here. If you find her guilty of second-degree murder or manslaughter, you have to address this form, this special finding form. Because you need to make and show that you have all determined beyond a reasonable doubt that during the commission of the said offense, the defendant did carry, display, use, threaten to use, or attempt to use a weapon. You have to make that separate decision. In this particular case, that is not going to be a hard decision to make. Ms. Redlick admitted that she committed this murder with a weapon. So if she's guilty of either one of the homicide offenses, she's clearly, you clearly check did. That's the sort of process. There's not really going to be a dispute. That should be not a hard decision for you to make because she did use that big, long, dull knife that she told me she did. So let's continue to talk about the jury instructions. We talked about reasonable doubt in jury selection. We talked about what that burden is, and we all agreed, or you all agreed, that you would hold the state of Florida to this burden. Not a higher burden, not a lower burden, not any other burden than this burden. To be beyond a reasonable doubt. So once again, you may have doubts at the end of this process. You are allowed to possess doubts. Provided those doubts are not reasonable doubts, you may possess those doubts and you may check the box finding her guilty and the box finding her guilty. State of Florida submits to you folks that it has proven this case to the burden that is required to prove. Okay, now we move to weighing the evidence, and this is when the rubber really meets the road for Ms. Redlick. The state of Florida submits to you that in this particular case, there are two witnesses that there is much of any sort of, I think, credibility determination that needs to be made in any large degree. Now, that's my assessment. My assessment doesn't matter. It's your assessment. Your assessment of credibility as to each witness. But my assessment is that the two witnesses who have the most sort of credibility or a credibility assessment that you need to engage in are Jaden Redlick and Danielle Redlick, mother and daughter. Every other witness you heard from was sort of a third-party witness, a law enforcement officer, an expert. You had some folks who were friends. Their testimony obviously isn't as meaningful or as weighty in the state's estimation than Jaden and Danielle's. So, we look at Terrell and Tucker. There is no motivation for Terrell and Tucker to lie about the fact that this defendant told her that Michael was saying Sam Katie on multiple occasions, once as he stood outside that door, for example. Jaden, we apply this set of rules for assessing witness testimony. Did she seem to have an opportunity to see and know the things she testified to? State submits to you that she did. Did she seem to have an accurate memory? Was she honest and straightforward? These are the things that you have to ask with each witness, Jaden and everyone else. Did her testimony agree with the other testimony and evidence? And as you go through each one of those, I would argue that she comes out on the side of a credible witness. She told you that she acknowledged her relationship with her mom is toxic. That her mom and dad.
What do you think of the state's close so far? Let us know. We want to hear what you think. Tweet us at Court TV. We're going to squeeze in a break. We'll be right back after this.
Today.
Back to the courtroom we go in Florida for more of the closing arguments. Let's watch.
Tumultuous. And she was asked, who is the source of that toxicity? Who was the source of issues within the home? And it did not appear that it gave her any sort of joy or happiness to say it was Danielle. The person who she lived, the person who gave birth to her mother. The person who killed her father. She told you that her father was trying to make things work when he moved back in. That despite all the trials and tribulations, that in this moment in time, he was trying to make things better. given her flowers, trying to improve this relationship. She told you that when she left on that day, her father's car was not covered in eggs. She told you that her father was a calm, sarcastic, funny drunk. State of Florida would submit to you that most significantly, she told you that there was never an occasion where in 2015 or at any time where she was brought to a hospital with her brother and father and mother to have her treated for an injury. She told you that never happened. And that if it did happen, she would have remembered it happening. Let me get to Danielle Redlick's credibility. At the end of the day, this case is in some large measure about her credibility. She has taken the stand, she has put her credibility at issue, and she is to be evaluated like any other person who came before you. She gets no special dispensation because she was the defendant. She is a witness like every other witness. And what you heard is that every single statement that came out of her mouth until she sat in that chair, until she had to look you folks in the eye, was a denial of responsibility. The state of Florida submits to you that her testimony before you over the course of a day and a half was just one more attempt to avoid responsibility for her actions, to avoid not being held responsible for the murder she knew she committed as she stood over Michael with the power to call 911 in the decision not to. So let's examine her credibility by looking at the jury instructions. Did she seem to have an accurate memory? Well, let's look at an example. She can recall with great specificity, incidents that occurred 10, 15 years ago related to things that make Michael Redlick look bad. But when she's asked, well, what did you do with the knife you used to murder your husband after you killed him, she can't answer you. She can't tell you. She could provide no explanation, no recollection of what she did with that knife. Because it's not useful for her to have one. She can't come up with one that's good for her because the only explanation is one that continues to incriminate her.